Good morning, everyone. Thanks for coming along. And I want to say a big thank you and welcome to Mark Higgins, who has very kindly come along this morning to take part in our roundtable podcast. I'll let everyone do introductions in a minute, but I just want to say a little bit about Mark. Mark is a barrister. He's head of faculty at BPP, called to the bar in 2005, entered academia in 2011 as a senior fellow with Advanced HE, recently presented to UNESCO on the many faces of equality on AI in information accessibility, and will be telling us a bit about that shortly. I'm Alice Diver, a senior lecturer in the law school, family law, not a lot to do with AI, but have to have certain opinions on it, which we can, I guess, discuss shortly. But I'll hand over to John Taggart.
Thanks, Alice. My name's John Taggart. I'm a lecturer at the law school in Queen's, University of Belfast. My background is in legal practice as a barrister, mostly focusing on criminal work. I completed my PhD and then entered academia, focusing mostly on criminal law, law of evidence, and sentencing.
Brilliant. And Liam Sunner.
Hi, my name is Liam Sunner. I'm also in the School of Law in Queen's University Belfast, and my background and research here at the moment is looking at areas of intellectual property, law, technology, and a growing component of this is in relation to legal education and artificial intelligence from a academic and student perspective.
Good morning, everybody. It's good to be here. In addition to what Alice said about myself, I've been in higher education teaching for 13 years. I teach a number of modules on our conversion course, so court, public law, criminal law, and I also teach on the bar training course, mainly advocacy classes. And in addition to that, I've got interest and expertise in family law, medical law, and jurisprudence.
That's great. So hardly anything. Well, that's brilliant. Thank you very much. Okay, and I'm going to be quiet now and hand over to John Taggart.
Thanks very much, Alice. Mark, I just want to echo what Alice said about giving you thanks for giving your time up today to speak to us for the Law Pod. We really appreciate it. We're going to talk about a number of things today, Mark. Things including life at the bar, your experience of the profession, legal education, which you're obviously involved in now. But the starting point will be your excellent paper, which you delivered at UNESCO, as Alice alluded to, on AI, and which Mark has kindly agreed we can provide to listeners as well. So, Mark, just to start off then, can you tell us a little bit about the paper you presented to UNESCO, and specifically your motivation for writing it and then presenting it?
Well, it's interesting how these things pan out, isn't it? I didn't list among my subject matter expertise intellectual property, and that's because I don't really know much about intellectual property. I did it when I studied for a year abroad in France. Didn't do spectacularly well in it, interestingly enough. But it's not a subject that you normally associate me with talking about. I was asked to speak at the UNESCO AI for IA, which is Artificial Intelligence for Information Access conference, actually quite some time ago, a number of months before I was going to deliver the paper. And initially I was going to talk about medical law, about personhood or something like that. But at the time, about a month before the conference, I think, an app was in development for the iPhone. The app, which has been around for quite a long time, it's called Be My Eyes, and it's a volunteer project whereby you can sign up if you can see. You can sign up to be a volunteer with Be My Eyes, and you will do a little shift where you're available to blind people from all over the world who might need help with reading cooking instructions or need help how to work their dishwasher or whatever, and they'll call you up and then talk them through it on a FaceTime call. But Be My Eyes started introducing photo description using AI And it really was a game changer because, as my paper gives some examples of, actually, it really gave a richness of detail to photographs which we didn't have at the time. And when this first started, it was a case of you could tell who was in photographs. You could tell, you could teach the AI to recognize people and so on. But then, due to privacy concerns, the photos the AI servers started receiving had faces automatically blurred out. Now, I thought, here we go, this is a really interesting subject matter. I find it incredibly frustrating, like a lot of other blind people, that we had all this detail about who we were looking at, and now we don't have it anymore. So let's talk about that at UNESCO. And that is how I ended up giving a talk on a subject matter I would not, for the life of me, have been giving a talk on 6 months previously. And the paper really makes the argument, first of all, that a blanket ban is not a good idea. Like all blanket bans, anyone who studies administrative law knows that if a public body applies a blanket ban to something, or applies a blanket policy with no room for exceptions, that's usually going to be quashed on for review. So blanket bans are not great, and so that was my starting point. How then do we reconcile the legitimate interest of privacy with not having a blanket ban? And really, the paper goes on to argue that the port of misuse of private information is a pretty good model for doing that. Essentially, I argue, using that port, that while certain things should be kept private in terms of photographs, I don't want you to take a snap of me in the street and find out who I am, all about me, and so on. Nevertheless, there should be a way of enabling facial recognition, matching up faces to your contacts, to your Facebook contacts, your LinkedIn connections, and so on. You give an app permission to have access to that information. I then conclude on the rather cautionary note that I have no idea whatsoever how you would implement that, but presumably can be done. So the paper really is beginning of the debate, and I say rather humbly that I'm not sure how you would implement what I'm suggesting, but I do think we should have a go.
Thanks very much, Mark. Just a quick follow-up on that before I hand over to Liam Sunner. Is there anyone else in this area writing anything similar, or has anyone picked up on any of these points you make, or has anyone made any academic arguments in a similar vein that you're aware of? Or if not, do you think there's scope for them to do so?
A lot of people are making arguments in the access technology industry along the same lines. I'm not aware that anyone has matched this up to the tort of misuse of private information explicitly in the way that I have done. However, the article's been picked up by a number of organizations. UNESCO is obviously a United Nations agency, so that helps a lot. And it's been picked up by organizations I would not actually have thought would have been interested. The Jamaican Broadcasting Commission, for example, which came as quite a pleasant surprise. The Financial Times have been interested, and we'll see where that goes. I think part of the interesting thing about all of this is that ever since I wrote that article, AI has moved on quite a bit. So it's an ever-shifting landscape. But it's available for people to read. It's available for people to watch, and people are reading it and watching it. So that's good enough as far as I'm concerned at the moment, because it's an issue that is getting publicity.
Great. Thanks, Mark. I'm going to hand over to Liam Sunner now, Mark, to follow up on AI and education.
Thanks, Sean, and thanks, Mark, for coming in. It's kind of a broad question, but it might open up some other avenues, particularly looking at your role as head of faculty at PPP. I was wondering, could you talk about your experience of AI in legal education and legal training?
Yeah, it's interesting, this one, because again, we're all rather new to this game, aren't we? But we are talking more and more about what AI can do, and just as importantly, what it can't do. So in England, AI helpful because a lot of assessments, for example, the solicitor's qualification examination, a lot of assessments like that are multiple choice question based. Now, AI can help you draft a wide array of multiple choice questions. It's quite good at giving you an initial draft, and you can then look at it and sense check it and everything. It's of course essential to do that, but from a tutor perspective, that's good, and also from a perspective because it enables us to give our students a wider question bank of practice questions. So that's one positive use of AI, which I think is helpful in legal education. I think also it's important for students to learn how to use AI properly in legal education. It can help you with your academic writing, can help you tidy things up. It can, if you are careful, summarize complicated concepts, I suppose. I mean, I imagine you guys have found the same. It's a bit like Wikipedia in a way. You can use it, but you've got to use it properly, and you've got to use it very carefully. I remember running a coursework question through AI. It was a constitutional law question, and AI informed me that currently Theresa May is the Prime Minister of the United Kingdom and that she heads a minority government. So you've got to be quite careful with that. The limitation with AI, and there will always be a limitation, is it can't reach value judgment. So, and it's something that I hammer home to myself. If you have a question that begins, how successful is X? To what extent do you agree with Y? AI is not really going to help you answer that. And I'm not sure that is coming anytime soon, if indeed it ever will, because it's hard to imagine AI feeling emotion, prioritizing things in a way that a human does. And that sort of filters down into giving advice. AI will probably be able to give you the correct legal advice, what the law is, but I still think you'll always need to be in the room with the client to understand what she really wants. Because clients actually don't always tell you what they want. It's often a case of reading between the lines as a practitioner and helping them identify what they really want, necessarily what they talk about the most. So I think AI and large language models and so on, I'm not sure that they'll ever be able to do that. And so there will always be a place for learning how to do that. So it's a case of understanding where it can be useful, and it certainly can be. I don't think there's any place for what some people approach it in the way of denying that it can ever be useful and rebelling against it entirely. There's no point in doing that. The technology is there. So acknowledging it can be useful for A, B, and C, but it won't help you with X, Y, and Z.
No, that's fantastic, and I absolutely agree. It's the aspect you mentioned about it being a value judgment, and we're just over the market period in Queens, and now kind of in my head, I'm revising questions of, rather than do you agree with the opinion, it's to what extent would you agree with a case law or judgment or a quotation. There might be something to feed into assignments for next semester where AI can't adequately address that level of value judgment. And that's a lot to think about. Thank you.
Mark, I want to go on to ask you about your career at the bar and transition or movement into academia. It's something you've touched on in some of your answers so far in terms of your interactions with clients, for example. But if you can loop back and just talk us through your entry into the profession, the bar, your route into academia, and maybe specifically focus on what challenges you personally faced along the way, because you've obviously done very well in your career. You're head of BPP, but everyone has their challenges in their professional journey. So just if we could ask you to reflect on that.
Well, I'm not head of BPP. I'm only head of faculty. I'm grateful for the promotion. I knew there was a reason why I was doing this, but no, I have no desire to be the dean. Not just yet, anyway. But yes, I'm completely blind, and so my background, I went to a special school, both primary school and secondary education, and that's a controversial topic because a lot of people would say that mainstream education is where disabled children, disabled school students should be. I think that's right in some cases. I think it's not right in other cases. My special school for the blind served me very well. I went on to Oxford. I did law with French. Absolutely loved it. Got a double first in that, but I don't like to talk about that. That's a joke, of course. And then I went on to bar school at the Inns of Court School of Law and got pupillage in a step family law and civil litigation, and I absolutely loved it. So I was doing a mixture of child law on the one hand, bit of matrimonial, but I didn't really find that terribly interesting, to be honest. But child law on the one hand, and contract, court, contested wills on the other, and that gave me a really nice mix, I think, of paperwork and advocacy. That's unusual for the bar in England. The bar in England and Wales is the standard advice you will get is, look, you need to specialise. You can't have a broad-based practice. I never thought that was really for me. I thought variety is the spice of life. Let's be a bit of let's be a bit of an all-rounder. And I used to get people giving me advice. Oh yeah, you've heard the phrase "jack of all trades and master of none," and my response to be, well, yes. And you've probably heard that all cliches are misleading in some way. You can be a jack of all trades and a master of a couple of them. Someone like Ben Stokes, the England cricket captain, is a testament to that. So I spent 6 years doing my thing at the bar, family law, civil litigation. I suppose the challenges, very interestingly, the challenges were different, I think, from those that most of your listeners might be thinking about. They'll be thinking about the statistics, how so few people get pupillage, even fewer get tenancy. My advice on that is worrying about that isn't going to change the statistics. If you're not in it, you won't actually get pupillage at all. So you may as well have a go. You can only be responsible for your own performance. Never worry about what you can't control, and you can't control how the other 1,500 applicants or whatever are going to do. So don't worry about it. My challenges were more, how am I going to cope with reading handwritten documents? How am I going to cope with reading documents that are handed to me last minute at court? How am I going to make sure I get to everywhere where I need to be? And I think there was a little bit of, these guys, lay clients in particular, these very vulnerable lay clients that you actually deal with in child protection proceedings, are they going to have confidence in someone with a very obvious and very visible physical disability? That was my greatest challenge, the logistics And most of them, funnily enough, they were sought outable. They were resolvable. They were, for example, I did not find that my vulnerable lay client lacked any confidence in me on the count of my being a blind person. I only had to complain about discrimination on background once in my 6 years in full-time practice, and the complaint was not about a lay client. It was about an instructing solicitor, which is surprising, isn't it, when you think about it? Court staff are very helpful. I managed to get from A to B. I'm told I'm a very confident traveller anyway, and that's probably true. But, still poses physical challenges, but I managed to do what I needed to. And the paper document issue, technology was not where it's at now. It's much easier to deal with that these days. But I got some assistance from the government to read me handwritten documents, to look at photographs to me, and we did have technology enabling me to scan in and OCR printed documents at that stage. So that was, I think, that was doable. I won't lie to you that there were challenges that subsisted, and that in the end, I think, wore me down a little bit. Access to an electronic library, you're going to have the sort of practice that I have. You've got to have a pretty good common law library to back it up. My chambers didn't embrace electronic resources to the degree that I needed them. That all has to be paid for, doesn't it? And it was a shame that we didn't get implemented sufficient that. I think we explored a role for the Inns of Court to play, and there was certainly a degree of that. I think we still need to go further with that. But in the end, I think that wore me down a little bit. The fact that I couldn't quite maintain the professional library that I needed, and the fact also photographic evidence was still very difficult at the time that I'm talking about, up to 2011. And, reflecting more and more on my paper, I do hope that will change with the enhanced photo recognition that AI now allows us to have. It will mean that AI will have to allow us, for example, to look at faces. It will mean that AI will have to allow us to look at not very pleasant photos. At the moment, you try and get Microsoft Copilot to look at something it deems as adult content, as it would put it, it won't let you. It won't analyze that. Now that's the sort of thing that AI is going to have to allow blind barristers to look at. So I mean, those are the challenges. We're getting closer, I think, to overcoming those challenges. They still exist, and they certainly existed in more acute form for me. But I'm now in academia. I very much enjoy academia. Somebody asked me the other day, do I miss my advocacy at the bar? And my response was, well, not as much as I should, if I ever want to go back to it. I loved the bar, and I loved examination. I loved the thrill of appearing in the Court of Appeal. I've never appeared in the Supreme Court, but Court of Appeal and below, I really enjoyed that. But I enjoy teaching more. So it wasn't just a logistic thing to switch into teaching. I enjoy teaching a whole lot more, and teaching is what I am about rather than research. I think the aspect of it that I enjoy the most, and that incidentally AI will never be able to enjoy, is going the extra mile for students. And when you get that back as well, it's fantastic. But yeah, that's sort of my journey. I had an academic sabbatical. I forgot about that. Academic sabbatical in 2016 to do the BCL. BCP very kindly let me go back to Oxford to do the BCL. So I've got a bit of a reputation as a jurist, as well as a barrister. But I suppose that's me in not quite a nutshell. I've carried on for quite a bit there, John, in response to your question. Sorry about that.
No, that was a fulsome and Very interesting description of your journey, Mark. And I'm glad you mentioned the jurist description, because I think it's really sums up your profile, which is fantastic. Mark, I'm going to hand over to Alice now to finish up with the questions. So thanks very much.
I have a couple of questions, but if time permits. First one, I just wondered if you had briefly any advice or tips for law students sort of coming up through the system. And then I wanted to be nosy and ask, I noticed that you mentioned about medical law is your next frontier, that you're wanting to sort of expand into that.
Well, in response to the first question, my tip for anyone coming up and looking particularly to the bar, but not just the bar, the solicitor, is to not worry about what you can't control. Take the fact that the candidates that you're going to have to be up against are very, very good. Take that as a given, because it is a given. You're going to have to compete against some very good people. You're going to have to be among the best of those people. You can't worry about what any of the others do. You can't control it, rather, so don't worry about it. It's a waste of energy. Worry about making your application the best you can. And you can do that from really early on in your degree. And I'm sure you guys say the same thing to your students. Don't let the law be something that happens to you. Don't let the law sort of pass you by. Don't read a case or read about a case and just accept that it must have been correctly decided because Lord so-and-so or Lady such-and-such said X, Y, and Z. I remember a question that I was asked on the Pew interview. Can you give me an example of a case you think was wrongly decided and why? And I think the biggest tragedy, particularly for the conversion court students that I now teach, but not just for them, is how much a lot of contemporaries struggle with that question because they haven't thought about what the law ought to be rather than just what it is. I'm teaching public law at the moment, teaching administrative law. And I said to my students in the first seminar, I want you to think about throughout the course what you think the legitimate role of judicial review is. And each of you will have a different answer to that. And if you disagree with my answer, great. You know, I might think you're wrong, but we're equal scholars here. So, you know, I pass that tip on. Always thinking about what the law ought to be. Don't just accept it. Don't be afraid to say that Lord Brown Wilkinson in whatever it was can't be right or has overlooked something, because your opinion does matter if it's properly reasoned. And sort of reasoning you're going to have to engage with when you are in court or when you are advising a client anyway. Yeah, the second question, medical law, is one of my options actually on the BCL, and I'm very interested in the subject. I'm going to be doing a little bit with our School of Health, for example, in the next year or so. I've written a paper on sort of crossover between family law and medical law about the experience of disabled parents in child protection proceedings. The paper's called The Exam It's Impossible to Pass. And it sort of segues from family law into disability law. But I've a massive interest in advanced directives, advanced treatment decisions, for example. I delivered a lecture on that at Oxford in 2017. And yeah, medical law, family law, those are my main areas where I'm looking to dig a bit deeper in terms of academic interest now. Not say that I'm not interested in the stuff that I teach. I am. But I think if I ever did a PhD, I'd want to do it on trying to develop a sound legal framework for advanced treatment decisions. Because many countries have very different approaches to end-of-life care. Much of it bound up with ethical, bioethical stuff. It makes it very, very difficult to harmonize rationalize what it is we're trying to achieve. But if I ever do a PhD, that's what I would like to attempt. And then I look at the length of a part-time PhD, and I think, goodness me, I'll be over 50 if I ever finish it. And then sort of saps the will, unfortunately. But I may yet take that task on.
I can only comment and say that life begins at 50, Mark. So, I think that's a PhD that's crying out to be done as you're in the prime of life still. Both the natural bedfellows as well, family law, medical law. It's an interesting one.
Very quickly, if I could just give a shout out, we have a very vibrant bioethics and medical humanities initiative here at Queen's, Mark. So perhaps we're laying the foundations here for future collaboration. So I'll maybe leave that there to percolate, and we can maybe have another podcast in the future on that.
Well, I think I saw one of yours at Law Teacher of the Year last week. Very impressive. So that was an advert, as good an advert as any for your student support, and this podcast, it does great things, and I'm really honoured to be on it. It really is fantastic. The opportunity and the pleasure is all mine. You mentioned a couple of times. It's great to have me on. I mean, really, I feel exactly the same.
Thank you, Mark. We're very grateful. And I think, unless anyone has any other final questions to fire at you, we will let you go and back to your life. And thank you again. As you say, hopefully what path we'll cross in the future.
I mean, can I just say that if anyone reads the paper on the many faces of equality, or indeed has a go at the exam it is impossible to pass, which is a bit longer, you're more than welcome to get in touch with me on LinkedIn, or to email me at BPP. I believe I'm quite findable. Mark Higgins at bpp.com. I'm very, very keen to hear what people think, including critiques of what I've said. So I'm really, my door is always open to feedback on that from anybody.
But Mark, thank you very much.